You're listening to Kerry Lutz's Financial Survival Network, where you get valuable information you just can't find anywhere else. To thrive in today's trying times, you need the Financial Survival Network, now more than ever. Go to financialsurvivalnetwork.com and get your free newsletter and gift. Financial Survival Network, now more than ever.
Welcome. You are listening to watching the Financial Survival Network. I'm Kerry Lutz, and it's time for another Triple Lutz report. This is episode number 492. Today, I'm going to be talking about the blockbuster Supreme Court case, New York State and Rifle and Pistol Association versus Bruin, and fascinating case in so many ways. I would say that this case for the Second Amendment is the equivalent of Roe versus Wade. New York State, I think in 1911, passed the Sullivan Act after some guy went crazy shooting people. And earliest example of an extremely restrictive gun licensing scheme, to my knowledge, in the country, became the model for a number of other states. What's interesting to note here is that this case goes way, way beyond just reaffirming Second Amendment rights and the right to get a carry permit. What it seems to imply is that virtually any restriction, other than perhaps mental illness or prior felony convictions or convictions for violence, outside of those things, really, anyone can get it. It's what you call shall issue. So there are two types of licensing schemes in the country, actually three. One is may issue, that's New York. We may issue you a carry permit if you can show special need. Then in like Florida and 36 states, it's shall issue, which means you will be issued a carry permit in the absence of disqualifying facts such as prior felony convictions, mental health issues, etc. Perhaps even children being allowed to buy it. A 16-year-old walking into a gun store, probably that type of restriction is still permissible under the court's decision. Now, this decision was ostensibly written by Judge Clarence Thomas. He's an ardent conservative. He's one of the quietest judges the court has ever known. During oral argument, it's very rare for him to ask any questions, raise any issues. And having read this decision, I haven't read a Supreme Court decision from cover to cover in over 20 years, I'm proud to say. That's one of the benefits of being a recovering attorney. It's brilliantly written. It's brilliantly written in terms of tracing the Second Amendment, what it means, what it doesn't mean, what restrictions are not permissible under that amendment. And as he says, no other amendment has had more limitations and qualifications that he knows of, and I got to believe that his law clerks know of. It's the only amendment that has been this abused. And pretty much the case was decided on the Second Amendment and the 14th Amendment grounds. Second Amendment, obviously, being the right to keep and bear arms, and the 14th Amendment, equal protection under the laws. It's just a masterfully written opinion, one that I haven't seen from the Supreme Court going back decades. It has a clarity about it. It has an articulation about it, and a logic. The reasoning is so sound. And that applies whether you're a Second Amendment gun lover like yours truly, or even if you're opposed to broadening this amendment, this right, this privilege. In theory, these rights in the Bill of Rights, going back to the Founding Fathers, doesn't give you rights. It acknowledges rights that already exist, your natural God-given rights, if you will. And so when he traces it, he says, look, you can't limit this by saying that you can only have a gun in your house. Obviously, the Second Amendment says you can bear arms, which means when you're walking around on the street, you can have arms on you. And it's fascinating because the minority, headed up by the liberal wing of the Supreme Court, makes the argument there's all these mass shootings, there's all these people getting killed, and really, this is the only way that states have to keep their citizens safe. And what's fascinating is that Thomas directly refutes that assertion by mentioning the recent mass shooting where 10 people were killed in Buffalo. Buffalo in New York State has these restrictive rules. And he said, if it's so great, why didn't it stop it? And he makes the point that really in today's world, as in the historical precedent for the Second Amendment, you need your gun the most when you leave your home. He mentions that during the development of the country, people lived far, far away. There were no police. Maybe there was a marshal or a deputy sheriff or sheriff, something like that, but that there was no cell phones. You couldn't just call a cop. And, you know, the Second Amendment proponents are always only too happy to say, when seconds count, the police are minutes away. And really, it's a huge milestone. I would say that this decision, the Bruin decision, is the Roe versus Wade decision for gun rights. Goes way beyond almost what the case was about, finding rights that perhaps weren't clearly enumerated in the original founding documents. The idea that, hey, you should just be able to have your gun for personal protection wherever and whenever you need it, other than perhaps in public buildings, in courthouses. I guarantee you that regardless what happens with these laws, you're not going to be able to bring a gun into federal court or state courts or your local town hall or city hall. That's just not going to happen. That's one of those restrictions that will remain in place, rightly or wrongly. I see the point of it. You don't want your courthouses, your government buildings to turn into Dodge City, let's face it. So just an incredibly clear and well-stated, well-reasoned decision. And the dissenting opinions could not even come close to it. They couldn't touch it in terms of reasoning. What's interesting is what is going to happen next here. What will be the fallout from this decision? Obviously, there are, I think, 6 other states that have highly restrictive gun laws: Connecticut, somewhat New Jersey, Massachusetts, California, Hawaii. These states, obviously, under the holding of Bruin, these restrictive gun laws are going to be struck down. So 2 things to understand here. There's really 3 types of gun regulatory schemes. Number 1 is may issue, and that's New York. You can get a carry permit if you want, but you got to show special need. And it can't just be you're scared of getting held up. It's like, I have a lot of cash, I carry gems, I carry bullion around, and you have to prove this. You got to show bank deposits, all these things. So that's may issue. Shall issue, which was sparked by Florida's right to carry law, is that unless you have specific disqualifying factors, i.e. a criminal felony background, felony convictions, or mental health issues, or domestic abuse, order of protection against you, then otherwise, absent that showing, they have to give you a carry permit. And then the third type of regulatory scheme is basically anyone can carry anytime. And you have this in Arizona, you have it in Alaska, you have it in, I'm trying to remember the other places where you have it, but basically it's called constitutional carry, where the government doesn't have, in Vermont as well, which you wouldn't think would be a Second Amendment state, but Vermont has never had a carry permit. meaning you have a gun, you can carry it with you. And so those three different types, it looks to me like this is clearing the way for universal reciprocity, because that will be the next case that comes in. I have a carry permit in Florida. Why can't I just carry my gun in New York State? So I think full carry reciprocity is coming across the country. It's going to be interesting to see. This will be fought out over the next several years. Look, the last case, big case on this was Heller, and that ruled that people in the District of Columbia had the right to purchase handguns and to carry them, to get carry permits. And this was used to strike down Illinois' very restrictive gun law.
Don't just survive, thrive. The Financial Survival Network.
Osino Resources is a Ross Beatty-backed gold exploration company in mining-friendly Namibia. Osino's district-scale land package is situated near two producing gold mines, one of which Osino's management team previously developed and sold to B2 Gold. Osino's founders and management are experienced mining professionals who have already successfully developed and sold two companies in the past 7 years. Osino has a tight share structure, and with its current treasury, it can self-fund the advancement of its gold discovery into at least 2022. This is an exploration company with drills turning that you'll definitely want to pay attention to. Osino trades in New York under the ticker OSIIF and in Toronto under the ticker OSI. To learn more, go to osinoresources.com. That's osinoresources.com.
This is the Financial Survival Network. The information you need to thrive now more than ever.
It's really fascinating. I mean, I see this as kind of a renaissance of the Bill of Rights, of your rights as an individual. We'll see if it carries through to other areas of the law. A fascinating thing. One thing I'd like to point out is that Florida, I think it was in 1987, passed the first and became the prototype right to obtain a carry permit legislation. And crime in Florida and states almost invariably that had full carry shall issue states saw their murder rates and violent crime rates plunge. Now, you could argue that this is a demographic trend, et cetera. But in Florida, the population has doubled or tripled. I think we're about at the same murder rate in this state as we were in 1987 per capita. The actual number of murders might have gone up. All in all, it's a fascinating decision, extremely concise, clear, well-written, having not read many Supreme Court decisions over the years because they carry on for hundreds of pages and they're muddled and they're just bad. There's a saying in the law, hard cases make bad law. Well, this was an easy case for Justice Thomas and the majority. You had some concurrences in there that don't really add or detract much from Thomas's decision. It was 6-3. Roberts even joined in. There were three, I think, 2 or 3 concurring decisions, just kind of chipping around the edges of it. So like I say, lots of lawsuits coming down the road. I don't see how federal courts have any leeway. Another interesting thing was Supreme Court decisions often remand the decision back to the circuit court or Supreme Court, state Supreme Court, where it came from, for basically for further consideration within the constraints of this decision. Remand for further proceedings that are consistent with this rule. The Supreme Court didn't do that here. In effect, it was so ordered. So I wonder right now, if you carried a gun in New York State, even if you didn't have a carry permit, it probably is legal right now until New York State passes a new licensing schema. They will overshoot. New York State will try to keep restrictions in there, try to keep some semblance of special need, but a showing of special need. But in the final analysis, it's not going to hold. Illinois gave up on it 5-6 years ago. Eventually, New York will have no choice but to comply. And so, like I said, nationwide carry reciprocity, it's on its way, because we have a thing called full faith and credit. and that is that laws that deal with specific subject matter, unless they're contrary to state law, have to be honored, which means like your driving license. You get one in California, it's good in Hawaii, it's good in New York, it's good in all the states. And I think that is where we're going to head next. It's going to be a battle. It's going to take place because these progressive states and governors and legislatures are not going to want to give in. But in the end, they're going to have no choice. This decision doesn't really leave any leeway for it. So exciting from that standpoint. But there were always loopholes to get guns. If you knew somebody, if you had a connection in New York City, you could generally get a carry permit. But I had a friend, business associate, they turned down his full carry permit in New York City. So he filed with them a Freedom of Information law request many, many years ago, demanding to know every permit that had been granted during the past 24 months, demanding to see the manual that the NYPD used for granting carry permits. And a week later, he got a call from the pistol permit section at New York Police Headquarters at 1 PD Plaza. And they said, hey, come on in and get your carry permit. It's been approved. And honestly, if there's one person that shouldn't have had a carry permit, it was this person. As far as I know, he's never shot anybody since then. But to me, personally, the thought of him having a carry permit was really kind of scary. But that's the irony. The other thing that many of you don't know about, in New York State, there's actually two licensing schemes. One is at the state level, and then one is at New York City. So even if you got a New York State carry permit from another county and say upstate, you had to get a special endorsement to that carry permit for New York City to allow you to carry there. Generally, they were mostly freely granted, but on occasion they would reject it, and then you'd have litigation. Generally, in New York State, the state was going to win no matter what in the city. One other interesting tidbit is that in the upstate counties, like rural counties in New York State, different ones like in Putnam County, Orange County, still kind of rural, they basically were very lax in their standards of what a special need was. And if you put forth any argument, you didn't have to document it. Generally, all other things being equal, no other factors like criminal or mental health, you were able to get a carry permit. But again, you couldn't take it in New York City. New York City it's so bizarre. I mean, I had one where I lived north of the city, not a full carry, but a target permit. And it wasn't allowed in New York City. Couldn't have the gun loaded in the car. You had to put it in a unloaded state in your trunk in a locked container, basically. And the number of people that got arrested for this was just absurd. So all this craziness now is eventually going to be over. Watch these 7 states, especially New York and New Jersey, and California, Hawaii, to fight to the bitter end. But they're going to lose. There's no question about that, barring a dramatic change in the court's composition, which I just don't see coming. But you never know. Never say never, Never say never, because you never know. You're dealing with courts. Courts are always, it's always a crapshoot. You think conservative court's going to rule one way, and they often surprise you and rule completely contrary to what you believe their ideology is. So it's a big day, though, because as one of my guests said, the Second Amendment guarantees all the other amendments, the right against tyranny, the right against, free speech, all these things, all based on the Second Amendment. Maybe that's a bit of a stretch. Maybe a lot of it's got to do with institutional history, legal history, precedent of the United States. But one thing is for certain, it's going to be a lot easier to get a gun and carry a gun in virtually any state in the country. Oh, like I said, when Florida passed its shall issue, I believe in 1987, it became the prototype for literally 35 other states. And you have reciprocity in these 36 states. They've signed their own compacts. So if you get a Utah carry permit, you can use it in Florida, a Florida permit in Utah, in places like Georgia, the Carolinas, Texas, Oklahoma, all these things. I think the trend here, and this seems to address open carry, some of the decisions, some of the reports there, the articles that you'll read say that this paves the way for open carry. I'm not sure of that. Florida, as liberal as it is with gun rights, doesn't yet have open carry. Texas, Arizona, they have it. Oklahoma, more and more states. I think half the states now, 25 or 26, provide for open carry. The trend here is obvious. Look, when seconds count, the police are minutes away. And in light of the recent social unrest in the country and the refusal or the inability of police to protect people, just look at the mass shooting in Texas recently. They actually protected the shooter, allowed him to, allowed him to finish up his dirty deeds before they went in and shot him. Actually, they didn't even shoot him. Some Border Patrol guy rushed over there with a borrowed shotgun and blew the guy away. You know, there's definitely an argument to be made that now more than ever, the Second Amendment is crucial to your life, liberty, pursuit of happiness, and personal and family safety. So I'd like to know your thoughts on it. Tell me if you've gotten turned down for a permit someplace, if you're going to reapply now, how you think this affects you. The email address, kl@kerrylutz.com. Don't forget, go over to financialsurvivalnetwork.com. If you're not there already, sign up for your free newsletter. This has been another Triple Lutz Report. Kerry Lutz, signing out.
Thanks for listening to Kerry Lutz's Financial Survival Network, your solution to today's trying times. For the latest, go to financialsurvivalnetwork.com. Financial Survival Network, now more than ever.